It's good to be with you. I know we don't have much time, so we'll jump right in. But perhaps for those who are not familiar with Syphius, maybe I can just start by describing what Syphius is and what Syphius does, so that we might kind of come together and understand why it might be important for your transactions. So Syphius is the acronym for the Committee on Foreign Investment in the United States. It's a committee of various member agencies of the United States government whose mission is to review certain transactions by foreign persons, that's the term of art, of U.S. businesses. That's another term of art. It doesn't have authority to review all such transactions, and it obviously applies terms of art, so its jurisdiction is to some degree limited. It's quite expansive, but it's not infinite. And its goal is national security. The reason Syphius has become more visible in recent months is obviously the increasingly strained relationship the U.S. has with China, although there are other factors to this. So with that, perhaps as a background, maybe we can just jump in, Christina, and just go back and forth a little bit about the 5 myths. Now, to be candid, there are more than 5 myths. We just selected 5. Because it struck us as a reasonable number.
And I was going to say, Mario, I think as a lead-in from my perspective, Syphius didn't exist definitely in my world for a while, and now it's the new kind of HSR antitrust checklist. So before I was only dealing with one thing, and now I'm dealing with 2 things. So Mario and I have become best friends.
Good. So Christina, actually, before I jump to I'd like to kind of prompt you on that, because I think that's maybe more important than anything I might have to say, which is, when did you just, in the course of your work, when did Syphius start to become visible? And we can turn to the myths in a moment, but I'm just sort of curious, like, when was it a much more prominent feature of how you thought about just going about what you did at Vista?
Yeah, I think it was when, it was definitely people were a little bit scared when they heard, we understood the antitrust process. If you got clearance, when you had to get clearance, when you didn't have to get clearance, and when there was risks of deals being either not approved or taken apart. And then there was this thing called Syphius that was passed. And I think the biggest scare was, when do you file? When do you not? I don't know. It's a little bit nebulous. Oh, and by the way, they can come in at any time and take your deal apart. So it was definitely a stressful item that was kind of brought to our attention a few years ago. I've gotten more comfortable now that we've worked through it and we understand it a little bit better and we know how to protect ourselves from it. But it definitely was one of those like, oh, there's another thing that we have to deal with moment when it first, at least came into my world.
Yeah. So maybe that's helpful context. So maybe we'll start with the first myth that we've identified, which is the idea that Syphius, is not relevant for small transactions, right? Or is not relevant for companies that are pre-revenue or have limited sort of operations. So one thing I'll just throw out as a practicing lawyer, we obviously see lots of different situations. I can assure, those in the audience that this is not true at all. In fact, interesting tidbit, there was a deal recently notified to Syphius whose transaction value was $1,500, which is, Kirkland Ellis did not work on that transaction, but nevertheless, there was a Syphius filing for a deal that was valued at $1,500. There is no de minimis threshold. And so this is a myth that I think is quite prevalent. I think to some degree, there's a corollary to the myth, which is that, well, it may not, the idea that it's a small deal, it's not so much that we don't understand that Syphius doesn't have jurisdiction, but the practical likelihood of Syphius reaching out is low because it's a small deal. Again, Syphius has a long history of contacting parties that have it notified for so-called smaller deals, and call those in for review. I don't know, Christina.
But I think it was because I think it was because of this history just in our minds of the government doesn't care if it's under a certain dollar threshold. And so that's sort of what you grew up with. And I would imagine, and I kind of assume the same thing. If you're still talking in a de minimis threshold, the government just isn't going to care. And you're right, that's just not the case here, which is part of what made it a little bit scarier until you really understand what the government is looking for. And then that's what makes it less scary.
Yeah, and I think you're. I mean, listen, it makes all the sense in the world. It's a reasonable assumption, but it's an assumption that doesn't bear out, at least in the Syphius context. So myth number one: Syphius is not relevant for smaller deals. Maybe we'll jump to myth number two. So another myth that we see, and again, we think most of these are fairly sensible, but they happen not to be true. Another myth we see is that you only need to think about Syphius when the initial foreign investment occurs. The idea is that only upon, I'm just hearing some feedback, so I'm not sure if the AV people can address that. Hello? Yeah, I think that's it. Okay, great. Um, so the second myth is that you only need to think about Syphius when you kind of do that, first transaction. And here, the point that I'd like to get to is in the fund context. um, GP stakes transactions, right? It may very well be the case that a fund sponsor has thought about Syphius on the way in to an investment. And post investment, there is a GP stakes transaction, which may change, it could change, the regulatory DNA for Syphius purposes of that fund, and nevertheless trigger Syphius jurisdiction. So, so that's one way in which Syphius can become relevant when actually the activity is happening elsewhere, sort of off stage left. In my example, in the upper tier of in the upper tier structure of a fund. Another way it becomes relevant, and this is a question I'll have for Christina. And again, Christina, we don't have to talk about Vista per se, but I know you talk with a lot of your colleagues, and we can just keep the comments general. But another way that Syphius can become relevant, again, outside of this initial investment context, is when you're setting up JVs um, with foreign persons, and the U.S. person is contributing a U.S. business. It doesn't come to mind, as that might be implicating a Syphius jurisdiction. But that's another way in which Syphius can become relevant.
Yeah, I agree. I think just from my perspective, the um, one of the places it becomes most relevant in my day to day, assuming you deal with your fund docs and otherwise, to your point, Mario, the GP stakes and the management company is, and otherwise they're just doing their ordinary course management of the funds. I think the one place it really comes in often is on co-invest,
Yeah.
and whether or not people are coming in direct, they're coming in through a fund. Obviously, we just get a lot of pressure from LPs these days, or I shouldn't say pressure, just interest in co-investing in our deals. And it's just become a much more prevalent practice. And so that is where probably the most questions will come up, because those will be sizable checks. And people will want to know how much they can take from certain investors in certain regions and not run into Syphius problems.
And again, one question, and we've seen that as well, obviously. And one question, which again is not directed to Vista, but more generally, just given your practice, have you seen co-investors become more understanding of the kinds of equity checks they can write, of the kinds of rights they can expect vis-a-vis a certain deal, in order to, frankly, keep the sponsor competitive for a transaction? Because sometimes Syphius can be the proverbial straw that breaks the camel's back in a transaction for a competitive U.S. target.
Yeah, I definitely have seen a change in an involvement. I'd say at the very beginning, this was sort of like when we had just registered with the government and all of a sudden people had new rules and parameters around them and they didn't understand. And it was everyone was frustrated and annoyed that they were now kind of doing things in a different way. I think that was kind of when Syphius first passed, and everyone still wanted to talk to all investors about all check sizes. And now we're saying, hold on, we need to go consider this. No one likes the slowdown and no one likes the extra, conversation with the lawyer, but that's what the reality became. And probably, I mean, that was like the first frustration was internal. The next frustration was with the investors themselves because they didn't understand this US rule of Syphius, and why Vista would be limiting them in their checks. It should have been the opposite. Vista or any other sponsor should just be extremely excited about big numbers kind of coming in. But then I think now we're in the world where everyone is very familiar with it. So you will see these big LPs. If they really want to invest in a deal, they'll wait to have their rights trigger until after a Syphius clearance. It is definitely something that LPs are more, we've kind of hit the first hurdle, hit the second hurdle, and now it's an active discussion with co-investors as opposed to a friction of why your lawyer is holding this up.
Got it. Great. That's useful context. Maybe we'll go on to our third myth, Christina, which is that this is a myth we hear all the time, that Syphius does not apply to investments into companies that are headquartered outside the United States. And just again, for the assembled group, Syphius applies to any to certain foreign investment that meets certain parameters into U.S. businesses. Right. And so the question is, how are U.S. businesses defined? And for Syphius purposes, a U.S. business is defined as any business operating in the interstate commerce of the United States. That could, and very well, very often has included businesses that are, frankly, completely outside the United States, but for a tiny rump. And that's enough to give Syphius jurisdiction. How have Christina, have you had opportunities to, talk with your colleagues about this, and have you seen this in your sort of day-to-day work? How attentive to these kinds of nuances would you say your colleagues, both outside and inside of Vista, are?
I think people are pretty savvy to it. I think the deal folks, it depends if it's something that they've dealt with before and then they understand it, or if it's something they haven't dealt with before, then it's kind of back to that initial hurdle that I was talking about before. But you're exactly right. I mean, now it's just a question, I think, all the time. So just us personally, if we have a company that is based in the UK, and all of a sudden the deal team is talking about selling down or having a big co-investor, and we come in and say, oh, well, let's just make sure we're running through Syphius. And they'll say, like, what are you talking about? And so it's just a little bit more of that education back to square one, of letting people know that it's always a concern. It doesn't matter where our companies are. Fortunately, most of our companies are in the US. And so I think it's something that people are much more familiar with. I could see it being a much bigger challenge on the sponsors that just are much more diversified, and again have deal teams that just don't deal with it on a constant basis, or at least aren't asking the question on a constant basis. And then I think it just takes much more education, just constant education, to make sure that it is something they're thinking about and at least raising at the proper time.
You guys are very, clearly Vista is a U.S. person, so the only way in which you guys have, as you've mentioned, think about this is in the co-invest, and you guys have been thoughtful and asked the questions. But just apropos of this broader point, other countries like the UK, like Germany, Canada, Australia have implemented Syphius-like regimes. They operate very differently, but one of the things that has been somewhat reported, but we have seen in practice, is more collaboration between regulators, sort of Syphius-like regulators across jurisdictions, particularly among U.S. partners and allies. So, Syphius in the United States, has quite a close relationship with its counterparts in continental Europe and the UK. The reason I raise it is because very often, for larger transactions, multiple Syphius-like regimes can be implicated, and sometimes we have seen clients really focus on one regime versus the other. And it will be important on a going forward basis for people to to take into account the fact that there are multiple legal regimes that can be implicated and that these regulators are increasingly talking. So Syphius is today with its foreign counterparts where the competition authorities were years ago. So it's moving in a similar direction. I know we're sort of running out of time, but we'll cover our last two myths here. So myth number 4, no Chinese deal can win approval. Obviously, Chinese deals have run into lots of headwinds, and there are deals that will never happen, candidly. But Syphius is more than about China. But even under today's circumstances, there are deals that we are seeing that are happening and that are being approved. They are few in number, again, but they are happening. And so, Christina, again, broadly, not so much about Vista. How do you guys think about China deals in terms of just your risk appetite, and perhaps on sell side transactions, right? Because Syphius is relevant not just when you're going in, but when you're disposing of assets. And again, the question
Yeah,
is not posed to this, but generally.
yeah, I was gonna say it's a little bit tougher of an issue for us because we don't have so many direct international platforms. We'll have add-ons, but not necessarily platforms. Um, and China is a little bit interesting too, because there was the market where they were really more interested in minority transactions. So you didn't see as many buyouts in China. So I do think it is something, and this is like Mario's pop quiz of mine. I think my question is always, where are you buying, and also what are you buying? What do they do? What kind of information do they have? Is this something that the government is going to be very interested in, or is it something that they won't care? And sometimes when we go through the analysis, something that's even as mundane as like making pencils for erasers, like Mario will tell me, oh, there's a reason why they're interested in that, which is not something I would think of. And then there's other industries where I would
That's not
think
a
they'd be
real
super
world
focused.
example. Yeah, that's not a real world example. I never made the claim about pencils, just to be clear. But
Yeah, no, that was yes, true. He did. This is not like authorized legal advice by Mario Mancuso right now. But I think I think it's those two things. I think it's where and also what, at least from my experience from having discussions about the topic.
great, thank you, thank you. Good. Our last myth is that Syphius is not relevant for startups, right? And so this is, again, as a working lawyer, this is clearly not the case. I think one point that I will say, I'm curious what your thoughts are, and I realize, Christina, in your line of work, you're not seeing such early stage companies, but Syphius's national security assessment really looks at not where a company is at now, but where it may go, how its technology may be applied. So we've seen Syphius apply to patent portfolios, for example, right? So that's the last myth. I don't know if there's anything else you'd like to add on there, but maybe you have a few questions for me to wrap up, or I can ask you some additional sort of broader questions. I know we're running very short
Uh,
on time.
no, I think, well, and I was going to say, I think it comes down to it's not also just the product that they do, it's also the information that they have access to. And so, kind of what information they're getting from their clients. And that's where I've also just made sure I pay close attention and see if that's kind of raising any red flags, startup or otherwise. Again, it doesn't matter on the size, but if they have access to very sensitive US, let's say, financial information, that may be something where, we're having the Syphius conversation much sooner than we otherwise would.
Great. Thank you. So now I think we just have a few more minutes left, Christina. It's your chance to give me a pop quiz. If you'd like, I'm happy to ask you some general questions as well.
I think the one just, and I'm going to ask myself a question. It's not really a question. I think the one thing that we didn't cover is how kind of what are other ways Vista or other sponsors are thinking about protecting themselves from Syphius. And I think we didn't cover the fund documentation. So Vista is a U.S. person, but we are putting provisions in our partnership agreements that give us extra protection from Syphius. And I think originally, again, kind of the hurdle analogy of getting everyone kind of comfortable of where we are. When you first started introducing those into your limited partnership agreements, people were kind of taken by surprise. You only invest in U.S. companies. You are a U.S.-based sponsor. Why do you need all these Syphius protections? Where I think today it's much more expected. And not only is it expected, but the LPs and investors are also making sure that we are Syphius compliant and asking how we're handling it and how do we handle the issues. So before it was just a very novice world. And now we're getting our own tests on it.
Christina, that's a really great point because, frankly, a sponsor's LPs are its clients. And, in our experience, again, as working lawyers, to your point about limited partners becoming much more sophisticated on the Syphius point, they appreciate not being put in a place where they're not embarrassed, i.e., sponsor makes an investment, there aren't the Syphius compliant procedures. There's the possibility that Syphius jurisdiction is implicated, and suddenly Syphius comes calling and starts asking for all this disclosure about not just the sponsor, but its clients, the LPs. So I think what you've just said, I think is just really spot on with our experience, that the more and more sophisticated LPs are expecting this kind of language because they're seeing that the environment has changed, but they're seeing that there is some institutional benefit for themselves. Right?
I'm seeing Adam come up, so.
Yeah, we have, it's time to thank you both. That was a fantastic and insightful conversation. So Christina and Mario, thanks for joining us at the Berkeley Forum, and we look forward to seeing you both soon.
Thank you.
Thank you.
Thank you.